state is either dissolved or is in suspended animation, the status of the state of Jammu and Kashmir as a state under Article 1(3)(a) of the Constitution and its conversion into a union territory under Article 1(3)(b) constitutes a valid exercise of power. I'll now read out our conclusions under different heads. Whether the proclamation issued under Article 356 of the Constitution of India and Section 92 of the Constitution of Jammu and Kashmir is constitutionally valid. We have held that this court need not adjudicate on the validity of the proclamations because, 1, the pleadings of the petitioners and the writ petitions indicate that their principal challenge is to the abrogation of Article 370 and whether such an action could have been taken during Precedent's rule. And 2, even if this court holds that the proclamation could not have been issued under Article 356, there would be no material relief which can be given in view of the fact that Precedent's rule was revoked in the state of Jammu and Kashmir on 31st October 2019. Further, the petitioners have assailed the specific actions which were taken when the proclamation was in force on the ground that those actions breached the constitutional limitations on the exercise of power after a proclamation under Article 356 is issued. These substantive challenges, which form the fulcrum of the case of the petitioners, have been considered. Next issue. Whether there are limitations on the exercise of power by the President or Parliament under Article 356. We have held that there are limitations on the power which can be exercised by the Union government in the state when a proclamation under Article 356 is in operation. We have reached the conclusion on the following grounds. A. The majority in S.R. Bommai, the 9-judge bench decision, held that the actions taken by the President after issuing a proclamation are subject to judicial review. However, the learned judges adopted slight variations on the standard needed to be applied by the court to test the validity of the exercise of power by the President after the issuance of the proclamation. Justice Sawant applied the standard of whether the exercise of power was mala fide or palpably irrational. Justice Reddy observed that the advisability and necessity of the action must be borne in mind by the President. 2. This bench, sitting in a combination of 5 judges, is bound by the decision of the majority in S.R. Bommai on the issue. We also undertook a textual and purposive reading of Article 356 in particular and Part 18 as a whole. We hold that there are limitations on the power exercisable after a proclamation under Article 356 is issued. The following are our reasons. First, the thread that runs through Part 18 of the Constitution, when read as a whole, is that differing levels of executive and legislative power are required to handle an emergency under Article 352 and under Article 356. This principle applies to the exercise of power when a proclamation under Article 356 is in force. Second, Article 356(1) states that the President may, by a proclamation, assume or declare the powers stipulated in clauses A, B, and C of Article 356(1). The powers stipulated in clauses A, B, and C of Article 356(1) are not automatically invoked when a proclamation is issued under Article 356. Third, Article 356(1)(a) does not opt for an all or none formula. The phrase all or any does not indicate that the Union government can exercise a part of the functions of the state government and the state government can exercise the remaining, because the suspension of the state government is an automatic consequence of the proclamation under Article 356. It rather indicates that the scope of the power exercised by the Union government must depend on the circumstances for issuing the proclamation. Fourth, clauses A, B, and C of Article 356(1) grant the President independent powers. However, the power provided under Clause C is broad enough to encapsulate the power of the President to assume functions under Clause A and declare under Clause B that the powers of the legislature of the state shall be exercisable by Parliament. Fifth, the principle underlying Article 356(1)(c) is that the exercise of power by the President must be desirable or necessary to give effect to the objects of the proclamation. The commonality in both the necessity and desirability standard is that the exercise of power must have a reasonable nexus with the object of the proclamation. Thus, the principle which runs through Article 356(1)(c) and which also guides the exercise of power under Article 356(1)(a) is that the exercise of power must have a reasonable nexus with the object of the proclamation. And sixth, When a proclamation under Article 356 is in force, there are innumerable decisions which are taken by the union government on behalf of the state government for the purpose of day-to-day administration. Every decision and action taken by
तो फैसला अलग अलग परंतु तमामनो निष्कर्ष एक होવાનો हाल जे વાત ચાલી રહી છે સુપ્રીમ કોર્ટની બેન્ચે ચુકાદો વાંચવાની હાલ શરૂઆત કરી છે બંધારણીય છે કે ગેરબંધારણીય છે તેની ઉપર હવે થોડા સમય બાદ ચુકાદો આવશે સીજીઆઈ જસ્ટિસ સૂર્યકાંત તમામ જે જસ્ટિસ છે તેઓ પોતાનો અલગ અલગ ફેસલો હાલ સંભળાવી રહ્યા છે પોતાનો અલગ અલગ પક્ષ મૂકી રહ્યા છે ત્યારે હવે થોડી વારમાં સુપ્રીમ કોર્ટમાં ફેસલો આવશે પરંતુ હાલ જે અપડેટ સામે આવી રહી છે એમાં તમામનો નિષ્કર્ષ એક હોવાની વાત છે અને સુપ્રીમ કોર્ટની બેન્ચે ચુકાદો વાંચવાની શરૂઆત કરી છે બંને પક્ષ તરફથી પોતપોતાની વાત મૂકવામાં આવી રહી છે સંવિધાન પીઠના 3 જજનો ફેસલો એક હોવાની અપડેટ હાલ સામે આવી રહી છે અને સીજેઆઈ જસ્ટિસ સૂર્યકાંત અને જસ્ટિસ ગવઈનો ફેસલો એક હોવાની વાત અહીંયા સામે આવી છે એ સિવાય જસ્ટિસ સંજીવ ખન્ના અને જસ્ટિસ કોલનો ફેસલો અલગ છે એટલે કે જે જસ્ટિસ હાલ તમામ જે વાત મૂકી રહ્યા છે તેમાં કેટલાકના ફેસલા અલગ છે પરંતુ ફેસલા અલગ અલગ છે પરંતુ તમામનો નિષ્કર્ષ એક હોવાની વાત હાલ સામે આવી છે ત્યારે સુપ્રીમ કોર્ટમાં હાલ